So, you've had a brilliant idea, you've done all the hard work, and you finally filed a patent application in India. Awesome. But then what happens? Today, we're going to pull back the curtain on that crucial and often pretty mysterious journey your application takes after you hit submit.
You file your application, and then nothing. For what can feel like an eternity, often up to 18 months, it can seem like your invention has just vanished into a big black box. But trust me, there's a very deliberate, very structured process happening behind the scenes. So let's open that box up and see what's inside.
All right, so the first big milestone, the first time your idea really sees the light of day, is what's called the publication stage. This is the moment your secret invention gets its formal introduction to the rest of the world.
Here's how it works. By default, the law says your application will be automatically published 18 months after you file it. Now, if you're eager and can't wait that long, you can actually request an early publication. And just to be clear, this isn't optional. It will happen, unless, in some rare cases, the application is withdrawn, abandoned, or has a secrecy order on it.
So what does publication actually mean? Well, it's not just some tiny notice in a journal. We're talking about key details, the date you filed, your name, the application number, all becoming public. But here's the kicker. The full blueprint, the complete specification, and any drawings you submitted becomes available for anyone to see. Yep, your idea is officially out there.
And this moment of publication is a huge deal, because it completely changes your legal standing. Before publication, that's the column on the left, your idea is secret, sure, but you've got no real power to stop anyone from copying it. But after publication, bam, you're on the right. The law gives you rights that are a lot like having a granted patent. This means you can start calculating damages from this day forward. But, and this is a big but, you can't actually sue an infringer until the patent is officially granted. Think of it like calling dibs. You're reserving your right to take action down the road.
Okay, so your application is public, great, but that doesn't mean anyone's actually reviewing it yet. And that brings us to the next critical stage, the examination. The key thing to remember here, it's not automatic. You have to kick things off yourself.
I mean, the law is about as clear as it gets on this. This quote from Section 11B basically says the Patent Office isn't going to just pick up your file and start working on it. Nope. You, the applicant, have to formally file what's called a request for examination. It's an essential, proactive step you absolutely have to take.
And believe me, you do not want to miss this step. If you miss the deadline to request an examination, the law just treats your application as withdrawn. Poof, all that work, the filing, the waiting, it's gone. So if there's one thing you take away from this section, it's this. You have to formally ask for your application to be examined. Period.
All right, so you've done your part. You've requested the examination. Now your application finally lands on the desk of an examiner, and the real deep dive begins. This is where your invention is put right under the microscope to see if it really has what it takes to get a patent.
So what's the examiner's #1 job? Well, it's all about looking for something called anticipation. Now, that's a fancy legal term, but it boils down to one really simple question. Is this invention actually new, or has someone, somewhere, already done it or described it before you filed?
And this isn't just some random search. The examiner follows a very specific procedure. First, the big boss, the controller, assigns them the case. Then, the examiner starts digging. They'll scour all the previous patent filings right there in India. But it doesn't stop there. The search goes global, looking at publications from literally anywhere in the world. And once they've gathered all that intel, they write up a report with all their findings and send it back to the controller.
And when we say they're digging deep, we mean it. I mean, check this out. For previous Indian patents, the search goes all the way back to January 1st, 1912. That's more than a century of innovation they're checking your idea against. And for everything else, they're looking for any document published anywhere on the planet, right up until the day before you filed. It's incredible. Your invention is literally being tested against all of modern history.
Now, the examiner does all this amazing detective work, but they don't actually make the final decision. Their report goes to the key figure in this whole drama, the controller. You can think of the controller as the judge, who weighs all the evidence and ultimately decides the fate of your application.
So this leads to the question that probably keeps every inventor up at night, right? What happens if the examiner does find a problem? Does that report come back with a big red no stamp on it? Is it game over? Well, not necessarily. The process is actually designed to be more of a conversation.
See, the law says the controller has to tell you what the main objections are. This usually comes in a document called the first examination report. And here's the crucial part. You get a chance to respond. You get to argue your case, to make your points, and to be heard.
And this back and forth, this dialogue, is where a lot of the action happens.
If the controller agrees with some of the examiner's points, they can require you to amend your application. Maybe you need to narrow one of your claims or clarify a description to get everything lined up with the law.
But let's be real, this conversation can't go on forever. If at the end of the day you can't fix the issues to the controller's satisfaction, they have the final power to refuse the application. It's the ultimate quality check to make sure only the applications that tick every single box get through.
And the controller's job is so much bigger than just saying yes or no. They're like the ultimate project manager for your patent application. They handle everything, splitting up an application if it has too many inventions, dealing with squabbles between co-inventors, and even setting that final all-important deadline to get your paperwork in order. They really do run the whole show.
So, okay, we've journeyed through this whole process. Publication, examination, back and forth with the controller. It's a lot. And it makes you wonder, right? Why does it have to be so complex, so rigorous? What's the big idea behind it all? When you boil it all down, every single step we've talked about is a form of quality control. Publication, that's for transparency. The examiner's super deep search, that's to make sure your idea is genuinely new. And the controller's final word, that's to ensure it's all legally sound. This whole journey is designed to do one thing: to make sure that when a patent is granted, it actually means something. It's a stamp of approval on a truly new and valid invention, and that protects the integrity of the entire system.
And that brings us to one last big question. This whole journey, this methodical, and let's face it, often slow process, it's all there to protect inventors and guarantee the quality of patents. But in a world that's moving at lightning speed, you have to ask, does this necessary diligence also act as a brake on the speed of innovation itself? It's a real tension at the heart of the whole system, and definitely something to think about.